Welcome back. You're still with us on Startup Street. The Ministry of Electronics, in the recent advisory on AI, mandates all intermediaries and platforms to seek government's explicit approval before deploying any AI models for users. Union Minister for State for IT, Rajiv Chandrasekhar, however, clarified on social media that the advisory was only for large platforms and not startups, and added that public internet should not be conflated with a sandbox insofar as unlawful content is concerned. Ashmit Kumar is here with more on the specifics of the advisory. Ashmit?
Well, importantly, a couple of aspects to bear in mind. One, the Minister of State for Electronics and IT, Rajiv Chandrasekhar, and Ashwini Vaishnav both have clarified in their own way. Rajiv Chandrasekhar, by way of a tweet, where he says that this advisory is in the nature of an advice to the intermediaries. That's one. Second, in a conversation with Ashwini Vaishnav, he clarified that as far as this entire advisory is concerned, it is not binding, only has a guiding force. That's the first key clarification. Of course, all of this issue came to light in light of this advisory which issued a mandate, so to speak, the advisory required for intermediaries before releasing and deploying their AI models, LLM models. It said that they need to take permission from the government. The advisory provided that there should be no bias or discrimination. It also said that there should be a labeling mechanism whereby the users are informed that the results may not be entirely accurate. Now, this has been clarified in part by Rajiv Chandrasekhar, who says that this is applicable only to large intermediaries, not to startups. Also goes on to say this is only for models currently under development, and that this will act as an insurance policy that tomorrow at a future date the customers don't sue the company in question. This question was also raised with Ashwini Vaishnav. He clarified on his part as well that there is, in fact, a need for more accountability. He, in fact, pushed the ball in the direction of social media companies, that is something that needs to be pursued further, and, of course, clarified that this is not binding as of now. But clearly, with both the ministers speaking in one voice with respect to the urgency that's required to tackle the AI issue, there is some indication being given with respect to the direction that future legislation may take on AI regulation.
Absolutely, it will. Ashmit, thanks very much for bringing us up to speed with that story. But joining us now to help us further understand this are legal experts, N.S. Napinai, Supreme Court advocate and founder of Cybersati, and MeitY Chaudhary, technology lawyer and founder of SFLC.in. Ladies, thank you very much for your time here on CNBC TV18. Ms. Napinai, I'll start with you. What is the legal basis for an advisory which both the ministers are terming as an advisory of this kind? Under what law can this be imposed on intermediaries and platforms?
That is a million-dollar question I would also like an answer for. Because unfortunately, the advisory which has been mentioned in all media is not available in the public domain. At least I haven't been able to come across this. However, some of the people who are claiming that they have seen the advisory are mentioning that it has been issued under the Information Technology Act 2000 and the 2021 IT rules. The 2021 IT rules probably refers to the intermediary guidelines. So now the intermediary guidelines are predicated on this one provision under the IT Act, which is Section 79, which gives an exemption or a safe harbor to intermediaries subject to certain conditions. One of the conditions is that they'll comply with whatever guidelines the central government may issue. The presumption, therefore, when a parent act gives an exemption and says that the central government can put in certain guidelines, is that the guidelines will be limited to and will apply to the aspect of the basis for the exemption. And here the basis for the exemption is that the intermediary has not initiated a transmission, does not choose the receiver, does not choose the content, or does not have control over the content. So when we are talking about all this, to expand it to cover AI rules, I think is a little bit of a stretch.
Yeah. Well, it is, because we don't really have clear rules on AI yet anywhere globally, leave alone India. But Ms. Chaudhary, the government clearly clarifying this is not applicable to startups. But, what is your understanding of these intermediaries and these platforms? What will be the large platforms? Are we only talking about the Googles and the Gemini AI models of the world? Or how will it not apply to the likes of Krutrim, say, in India? How do you distinguish between the two?
I think that's why the advisory should not have come with a clarification required by the minister through tweets. The few things which you are referring to, that it will only apply to large, significant social media intermediaries, tells us that startups are exempted. We do not know on what basis, because the example you gave, Ola's Krutrim itself, rates itself very low, in fact, or not low perhaps, but at least 7 out of 10 on terms of political neutrality. So why only the large companies are being subject to this and not the smaller ones? If the concern is interference with electoral process or deepfakes, etc., we do not know. The minister is also claiming this will be an insurance party. There is no legal basis that the government can become an underwriter or give any kind of insurance. If I, as a private party, tomorrow want to sue Google or Meta or any of the open AIs, so we do not know on what basis that actually is going to work. Third, if it is an advisory and it is legally non-binding, and I've seen it, and I'll Napina is a dear friend. I'll send it to you, Napina, and you'll also be amused to see, because it does say there will be penal consequences under the IT Act. It also requires an action taken come status report to be filed within 15 days. I will say elections are coming right now. So obviously a legislation or an actual rules does not seem to be possible. This seems more like we have to address Gemini's problem, which we saw on February 23rd, the answers it created. All over the world, because I do work in the US, there are regulations coming, and EU is right now at the gold standard based on harms that can come. So regulation which should be light-handed and not interfere with an evolving technology, which is evolving at the pace AI is. I think that's what's required right now, not a rushed way where everybody has to figure out and scramble to understand what exactly is happening, who's subject to it, who's not, is not what addresses the issue entirely.
Okay. Ms. Napinai, we just have 20 seconds to go. The minister saying that public internet should not be conflated with a sandbox, but, the answers you get on generative AI, for instance, that's used on various things, right? I mean, it depends on the training data, your prompt, the setting context, and so on. It's a private conversation. Can platforms really be held liable for this? In a few seconds, Ms. Napinai.
Very, very quickly, all that I would have to say is, if you want to hold platforms liable, do so under Parliament enacted law or under a proper parent act which permits you to issue rules, regulations, advisories or guidelines which has a legal flavor. To do so by expanding existing law to such an extent that it will merely break may not be the right way. AI, and what I was intervening earlier on was, you do have a regulatory framework under the European Union. You have the AI Act directive which has come out, which will probably be adapted by the European Union nations. So that's the right way. Have a law and then regulate under that.
Yeah. All right. Unfortunately, we ran out of time. Ms. Napinai, Ms. Chaudhary, thanks very much for your time here on CNBC-TV18. On that note, we're going to wrap up this edition of Startup Street. Thanks very much for watching.